Harneys key speakers. Let me call Mr. Antonis Frangoudis, the Director in OEV's Business Development and Economic Affairs Department, for a short welcome speech on behalf of the Director General, Mr. Michalis Antoniou. Adonis.
Thank you, George. Good afternoon, ladies and gentlemen. I would like, first of all, to express the sincere apologies of the Director General, Mr. Antoniou, for not being here with us today. And taking this opportunity, I would like to welcome you to today's online presentation on Russian sanctions, understanding the impact, which is jointly organized by the Cyprus Employees Industrials Federation and the international law firm Harneys. It is indeed true that the Russian invasion in Ukraine has impacted the global economy, causing prices of several commodities, including energy, to rise up on top of the pandemic's effect on various industries. Cyprus, being a major business partner with Russia, has severely been affected by the subsequent sanctions imposed by the EU. We might say that Cyprus is disproportionately affected compared to other countries due to the structure of the economy and our reliance on the Russian market. In addition to tourism and real estate, the financial, fiduciary, and corporate services sectors are among those that felt the shock. OEV, the main representative of the business community in Cyprus, has expressed its concerns over the consequences of the war and following sanctions that demanded facilities and relaxations for the affected businesses in order to mitigate the effects. As I mentioned earlier, Cyprus has close ties with Russia, but at the same time, we are a full member of the European Union. So despite the negative effects of the sanctions in our economy, we are obliged to follow the decisions taken by the European level. The sanctions and restrictive measures, especially for the professional services sectors, are complicated to understand and also keep evolving over time. Significant questions arise all the time about applying the measures for the financial and corporate services sector and to the expected impact on the Cypriot economy. The experts from the international law firm Harneys will give you an in-depth overview about the measures in our effort to provide further understanding. The experts will also give you practical examples which members of OEV can relate to in the ordinary course of business and how these should be dealt with to protect their businesses and customers, as well as a review of measures available for exemptions and related procedures with the competent authorities. Having said that, I would like to thank again our associates from Harneys for their input and assure you that the Cyprus Employees and Industries Federation will always be at the disposal of the business community to overcome another challenge. We all hope the war will end soon and normality will be gradually restored. Thank you, and I wish all the best for today's webinar.
Thank you very much, Adonis, and thanks to OEV, of which Harneys is a member in Cyprus, for co-hosting with Harneys this webinar, which I'm sure everybody will find fascinating and very interesting in these strange times. As mentioned before, today we're joined by two keynote speakers, Mr. Aiki Korsonia Hussein and Ms. Elena Mandruli. Aiki is one of my partners at Harneys, one of the good ones, and head of regulatory in our global tax and regulatory department. He specializes in all aspects of contentious and non-contentious financial services, anti-money laundering, and information exchange law, covering the EU and BVI law. Elena is a senior associate and a member of our tax and regulatory practice group. She regularly advises clients on regimes governing banks, investment funds, investment firms, securitization structures, payment services providers, and fiduciaries. We will be mainly discussing today the restrictive measures and sanctions issued by the European Union on Russia in light of the ongoing situation in Ukraine, with an in-depth focus on the measures affecting the financial and corporate services industries in Cyprus, as well as a review of measures available for exemptions and related procedures with the competent authorities. The webinar will also include practical examples which members of OEV can relate to in their ordinary course of business and how these should be dealt with to protect their businesses and customers. A Q&A session will follow after the presentation. So without further ado, let us start with the presentation. Let me try and share my screen. Ike, over to you.
Thank you very much, George, and thank you everybody for attending. I'm delighted to be talking to you today on Russia sanctions, trying to delve a little bit below into the detail of what these sanctions mean for all of us. The focus of this, I think, is inevitably on financial services, corporate governance, and those sorts of things, as opposed to other areas such as shipping, export control, luxury goods, and similar. If there are, we will of course try to answer any questions that you have as best as we possibly can, but to manage expectations, in case we don't know the answer, you know, we are the sort of firm, we will put our hand up and say we don't know right now, but if there are any queries like that, we can certainly go away, have a think about them, and come back to you. The other thing I would mention is that we do regularly maintain a very detailed update service on our regulatory blog, so we can circulate the subscription information for that blog through the chat functions, and if anyone wants to sign up to receive those, it's all free of charge. Then please feel free to fill out the forms and send that through to us. Right, so let's get started then. So we're gonna we've got the contents page up here. So we're gonna look a little bit at a macro level first at the global position for sanctions and restrictive measures. We're going to focus in the second part on how those measures are implemented in Cyprus. We of course talk about Cyprus being a full member state of the EU, but then the question is, how is that actually transformed into Cypriot rules and regulations? And so we'll look at that. We'll also look at the key division within sanctions law and practice, which is sanctions dealing with sectors, trade sanctions, let's say, and those sorts of sanctions that deal with asset freezes on companies and individuals. As George mentioned, we'll then look at some practical examples, and then the second part of the session is really looking at a Q&A session. So let's get started. Next slide, please, George. So sanctions and restrictive measures globally. Let's go to the next slide. Okay, so here the purpose of the introduction here is to contextualize the current crisis involving Russia, Ukraine within the broader sanctions framework that exists globally. As we say in the title here, sanctions are a new-ish global tool of foreign policy. The reality is sanctions have been around for many years, especially in the US and at the UN level. It's been relatively recently that the EU has really taken charge as an active bloc within the global community, proposing sanctions. We're seeing it as a key strategic foreign policy tool, and it's clear that, you know, whereas in the past states may have existed differently, I think the interconnectedness of the global financial community now means that if one particular sector throws a spanner in the works, that can have serious implications for perceived bad actors in the world. Of course, we can't lose sight of the fact, as Mr. Frangoulis mentioned, that when we do throw that spanner in the works, we do have a tendency to disturb supply chains, and that can then, whether we're talking about oil, wheat, whatever it might be, there can be unintended consequences down the line of sanctions policies. So getting back to the law then, the usual place where sanctions come from is the United Nations Security Council, as we mentioned here. So when there is global agreement, we do see sanctions with a capital S implemented. And so we've seen these over the years in covering places like Libya, Mali, North Korea, Iran. And I'm sure people on this call would have seen those regimes and events in the news. For Russia, though, the UN Security Council can't really do too much because, of course, Russia is one of the 5 permanent members on the council. So in that situation, what tends to happen, and we saw this also to an extent with Syria, is that you will have blocks implementing unilateral sanctions. EU, UK, US, obviously post-Brexit, UK has its own foreign policy outside of the EU. There is technically a distinction as well in nomenclature. So on the one side, we talk about sanctions, which strictly speaking are instruments released by the United Nations, whereas restrictive measures are those measures that are released formally by for example, the European Union. Cyprus, of course, does implement EU sanctions directly, but, oh, we've gone too far. Am I being told to speed up there? So basically, Cyprus it will, of course, need to implement. Sorry, George, should we just go back a little bit? One more back. Yeah, okay. Let's hold it there for a second. So Cyprus, of course, as an EU member state, does implement EU sanctions automatically, but at the same time, we can't lose. Sorry, the slides keep moving around. All right, let's put a firm lock on that slide number 5, please. Okay, so so the point I'm trying to make is that although we're sitting in the EU, we can't lose sight of other sanctions regimes that are out there. Sanctions is a rare area of law where the sanctions themselves attach not to where you're physically based, as most criminal laws do. They actually attach to your nationality. So in Cyprus, obviously, there are many Cypriots who hold UK nationality. We've got many UK nationals more broadly. We've got people in the bases and all of that. The bases themselves are UK under UK sovereignty. We also see in the financial services sector lots of BVI Cayman companies used in structures. Those are companies under UK jurisdiction ultimately. So we can't lose sight of the UK regime. Equally, we can't lose sight of the US regime. Most people will probably know that if you use the US dollar, then the long arm of US jurisdiction can extend to you. And we've also seen over the years, the US authorities having direct dialogue with the Cypriot authorities to ensure that Cyprus does not act as too much of a safe harbor for persons that the US doesn't like. And we saw this in particular in around about 2018, when various oligarchs were being sanctioned under the Trump regime, and there was some controversies there involving Cyprus. So we can't lose sight of UK-US. There is a gap between the regimes. Broadly speaking, as far as Russia goes, UK, US, EU act in concert. They act in constant dialogue. One tends to know what the other is doing. That really hasn't changed post-Brexit. There was some concern with the UK being outside of the EU that would go. Hasn't really impacted too much as far as I can tell. But there are still gaps. So, for example, as most relevant to the present discussion, in the UK and the US, there is currently a ban on the provision of accounting services to Russian nationals. That isn't a current ban in the EU. But then there is a EU ban on trust services which doesn't exist elsewhere. So we need to be on top of all of these other issues at all times as well. And with that, I will hand over to my colleague Alina, who will run through the way that sanctions are implemented in Cyprus.
Hello, everyone. Hi, everyone. Sorry, that was a bit of an interruption there. So, George, maybe you want to switch to the next slide. So, as Aki mentioned, now we're going to run through how the regime is implemented effectively in Cyprus. So, as we all know, Cyprus is an EU member state and therefore is required to implement the EU's common foreign and security policy domestically. In this respect, the way that the procedure works in terms of implementing sanctions, you firstly have the Council of the EU agreeing on the sanctions unanimously. So you may have heard in the news from time to time about the importance of the decision being made unanimously by all members and the fact that members have a veto. This is ingrained in the decision-making process at the level of the Council of the EU. And this is very important, as we will discuss later on, in relation to certain measures which are controversial and on which differing member states have different interests. Once such a unanimous decision is made by all the EU member states, the EU will then issue through regulations and decisions the relevant measures which are adopted and which will apply across the EU directly without further measures needed in order to apply in the member states. Importantly, I would say, is that beyond the requirement to apply those measures as a prohibition, the EU also expects that its members will give effect to the measures, and breach of those measures are required to be effectively a breach of criminal law. So what this means is that local legislation is required by each member state effectively to introduce criminal liability for breach of the sanctions. Now, in Cyprus, this has been implemented through the implementation of Sanctions Law 2016. We will discuss specific penalties under this law shortly. In terms of the competent authorities which are responsible for the implementation of the sanctions in Cyprus, including the departments to which the relevant interested parties in Cyprus can reach out to for any inquiries or assistance, including in relation to exemptions, which we will discuss later on in this training. These effectively, in the context especially of financial services, which is the focus of today's seminar, these are basically in the first instance separated between two departments subject to the Ministry of Finance. This is SEOC, so Financial Sanctions Advisory Committee on the one hand, which is mostly in charge of issues relating to banking, freezes of bank accounts, and this realm of issues. And then there is also the Sanctions Enforcement Unit, also referred to as MEC, which is responsible for inquiries that are made by interested parties. So unregulated companies, law firms, accounting firms who require assistance or who wish to apply for exemptions, for permitted exemptions for that are provided for under the legislation, MEC is responsible for these kind of inquiries. Now, these are the two central institutions which regulate and process inquiries from the public and requests. But the way that it works in Cyprus is effectively that competency for various requests is spread across a number of institutions. So as you can see on the slides, we have CySEC, so the Cyprus Securities and Exchange Commission, in relation to a range of financial services, investment funds, investment firms, and so on. Then you have the central bank, naturally in the context of banking, payment services, electronic money, and so on. The insurance company's control service for insurance and reinsurance related business. And also, there is also a role for the Ministry of Finance and the Ministry of Foreign Affairs, depending on the particular circumstances of the case. So this is the universe of competent authorities involved when it comes to implementing sanctions. I would mention that SEOC and MEC are each comprised of members from a cross-section of these institutions. So the central bank has representatives on SEOC, and there is representation on these committees from the relevant ministries that are responsible for making certain decisions. George, can we switch to the next slide? So going back to what we discussed earlier about the 2016 law, as I mentioned, it is necessary to implement local legislation to give rise to criminal liability for breach of the law. Now, the relevant penalties in Cyprus, I think the most important one that we all care about is that there is imprisonment involved in the event of a breach, possibly not absolute. In the event that the alternative to imprisonment is, of course, a fine that may be imposed. As you can see on the slide, that is a fine not exceeding 100,000 euros, or in the case of a legal entity, that is a fine not exceeding 300 euros. That, however, is not necessarily the end of the story, because it's important, especially in the context of regulated institutions, to remember that there is a risk of losing one's license or having it cancelled if you're a regulated institution found to be in breach of the sanctions. So for example, if you're a CISEC regulated institution, you may see that the regulator requires you to suspend or withdraw your license in the event that you are found to be involved in a situation of breach of sanctions. There is also the risk that a breach of sanctions will lead to your own designation under the relevant asset freezes in the event that it is considered that you are taking steps which offend the broader policy considerations and intentions of the measures. And there is also, of course, the risk of breach of contract under other contractual arrangements. We are currently seeing an increase, of course, with the current environment of sanctions clauses in the relevant agreements that various providers are required to enter into. So that is something that should also be taken into account when considering the impact of a breach of sanctions on your business. And finally, you may see that there is personal liability for directors, officers, employees involved in a breach of sanctions, even though this may be done in the context of a particular legal entity. So, George, do you want to go to the next slide? Now, having run through the issues specifically as to how this is implemented in Cyprus, we thought that it would be useful before we jump into analysis of the key restrictions imposed by the more recent sanctions, to just have a run through of the chronology of the sanctions. So it's important to mention that the process by which these sanctions on Russia started. This started back in 2014, which was the source also of the Ukraine-Russia conflict, and which has now escalated significantly. The launch of that conflict was eventually started from the situation with the misappropriation of assets by the Yanukovych government at the time, which was in power in Ukraine at the time. This ultimately led to the annexation of Crimea by Russia and the rise of separatist movements in the Donbass region. And this is where we saw the beginning of an attack by Russia on Ukrainian territory and the source of the 2014 sanctions. Now, just by way of an overview on the 2014 sanctions, we set out on the right side of the slide there an overview of the key provisions which introduced the measures. So, taking them one by one, Regulation 208 effectively imposed certain asset freezes in the context of the misappropriation of assets undertaken by the Yanukovych government. Regulation 269 was also imposed asset freezes on a number of persons, but that was in the context of the annexation of Crimea by Russia. These are asset freeze provisions. Regulation 692 introduced effectively a total ban on transactions in Crimea. So that was an embargo on business with Crimea. following its annexation. And Regulation 833 imposed a variety of trade and sectoral sanctions. So that is on specific activities and on specific sectors to restrict the ability of EU persons to do business in that way. Now, moving on to the 2022 measures. Just a second. So moving on to the 2022 measures, we'll run through a range of packages. So you may hear in the news reference to the sanctions as various packages. So far, we have had 5 packages which have already been passed and adopted and are implemented in Europe. There is a 6th package in discussion, which we will briefly touch on shortly. Now, in relation to running quickly through the waves in which the measures have been introduced, the first package was introduced upon effectively the invasion of Russia into Ukraine, the first day, tax rolling in effectively. And here we have the embargo on dealings in Donetsk and Luhansk being introduced. Further measures were introduced a couple of days later, effectively cutting off Russia, so the government of Russia, Russian central bank, from the capital markets, and the first wave of mass asset freezes. This is also the beginning of the gradually increasing bans on energy imports from Russia. It also introduced certain visa restrictions, and you may already be aware, certain bank account restrictions on the acceptance of deposits from Russian persons. We will cover some of these issues in more detail later on. Moving on to the 3rd package, the central bank was specifically sanctioned. The SWIFT ban, cutting off certain Russian banks from the global SWIFT system, was introduced. And additionally, certain restriction on exporting euro banknotes to Russia were also imposed. There was also a media ban on a couple of Russian stations that you may already be aware of that are now not available in Europe as a result. Then we move on to an interim package referred to as the compliance package. This effectively introduced a number of restrictions on Belarus, enhancing effectively the existing sanctions regime in Belarus. Many of the measures under this were now basically raised to match the prohibitions under the Russian sanctions, so they are to a certain extent equivalent. There were also further bans on SWIFT, and in addition, they extended the freezes, the bank account, the equivalent measures on bank accounts and so on were now extended to include crypto assets. Moving on to the 4th package, there is now introduced additional, I would say, and you will see why I say this in due course, additional prohibitions on transactions with Russian state-owned entity. This was also the point at which the iron and steel ban is introduced, and also the luxury goods export ban. And then moving on to the latest package that has been adopted, this introduced the ban on coal and road transfers by Russian businesses, and also introduced the ban on access to EU ports. And quite importantly, in the context of today's seminar, it was the introduction of the prohibition on acting as trustee in relation to specific trusts and related entities. Throughout this entire process, asset freezes were introduced with each wave as well. So now we have a very, very long list of asset freezes as well. Now, we mentioned the existing package, and you may already be aware that a 6th package has been discussed and was announced just last week as up for discussion among member states. Now, it is important to say here that this package has not yet been adopted or approved by member states. What we have so far is rather an announcement resulting from a speech made by Ursula von der Leyen on the 4th of May. And what we know so far, and it's important to say we don't have a text to consider beyond just the speech given by von der Leyen. What we know so far is that there is proposed a complete import ban on all Russian oil, both seaborne and pipeline, crude and refined. proposal to exclude Sberbank from SWIFT, which so far has not happened. So the intention behind this is that Sberbank is the biggest bank in Russia, and this will hurt. One of the reasons they have not been included is expected to have to do basically with payments to Russia for Russian oil so far. And finally, as most relevant, I believe, to many of us today, is a proposed ban on services by accountants, consultants, and spin doctors. We don't have any further information at present as to what it is proposed for this to include, unfortunately. Now, as I mentioned earlier, this has not yet passed into law or adopted. In fact, what we are seeing is that a number of member states are objecting to a number of proposed new measures. For example, Hungary has already come out and said that they intend to veto the oil embargo unless specific exceptions are made. The Czech Republic and I believe Slovakia has also come out with certain objections to issues relating to the oil embargo. As far as Cyprus is concerned, we too have objected to the proposed measures on the transfer of Russian oil from European flagged ships, and of course the measure banning the provision of consulting and accounting services. We do not, unfortunately, have a further update at this point as to the status and developments in this respect. We are all watching very closely to see what in the end will be agreed on in this respect. George, do you want to go to the next slide? So now we will switch to a more detailed review of the trade restrictions. So like I mentioned earlier, not the asset freezes, but rather more general prohibitions on specific activities. And for this, I will hand over back to Aki to run through.
Thank you very much, Alina, for that great run through there. So EU trade sanctions and restrictive measures there. So this slide looks at the pre-2022 position. Now, the trade restrictions on Russia first came in 2014 after around the time of the annexation of Crimea. And they were groundbreaking at the time. We'd never really seen these sorts of restrictions under EU law in the past. Up until that point, EU law in sanctions had essentially comprised of asset freezing measures, and export control restrictions. But here we start to see measures that are targeted towards limiting the ability on Russian state-owned institutions and credit institutions having access to the West for financing and lending opportunities. So what we typically see here are restrictions on the ability of certain designated institutions, just naming some names, Sberbank, VTB, Rosneft, Gazprom Neft, so Gazprom Bank, from being able to essentially raise finance, whether that be by equity or debt in Europe. And so what that looks like in practice is an outright ban on the purchase of shares or bonds or notes or whatever it might be from those institutions in Europe. It also impacts on investment services in relation to those services. So any ancillary services that are there to try and assist these big Russian institutions to raise funds in the West are installed there. The other highlights of the pre-2022 position that we have restrictions on the exploration of Arctic oil, any assistance provided to Russian firms through the production of technological solutions or any operation equipment that Russian firms require in order to explore the Arctic is outright banned as a sector subject to restriction. And then we have the outright ban on anything to do with Crimea and Sevastopol. So we effectively treat this as a de facto embargo of that region. And as Alina mentioned, it's very interesting because in the post-2022 or the current situation, we actually see the same approach taken now for Donetsk and Luhansk. Russia recognizes those countries as states, and then the EU immediately embargoes those regions. So in this case, we saw this with Crimea back in 2014, and there is essentially an outright block on any transactions with those jurisdictions, and it can be very difficult to advise clients who are stuck in these frozen regions. Next slide, please. So moving forward then to the current measures. So here we're looking at the current package of trade sanctions in place. I should mention, it's not mentioned on the slide, but all of these trade sanctions are included within the regulation, the cornerstone regulation for our purposes, which is Regulation 833. It contains in encyclopedic wealth really all of these restrictions. So checking down all the restrictions in that regulation, we see that, so the first one there that pops up is an outright prohibition on any capital markets assistance to Russia and its government, the central bank, or persons acting on their behalf. So that's effectively any sort of sovereign debt of Russia or similar is effectively now off limits to any EU person. There's a prohibition on new lending or credit arrangements with the above persons from the 23rd of February. This was one of the restrictions in that very first round of sanctions in the first package, second package possibly, first or second, and so we have an off-limit sector there, anything to do with the Russian state. Next slide, please. More relevant for possibly everyone on this call is the ban on it. We've called it a key enterprises transaction ban. So this is in the article ref is Article 5AA. So under that article within Regulation 833, a long list of key Russian strategic companies are listed. Some of these you will for sure know: Rosneft, Transneft, Gazprom, Neft, Rostec, etc. These are specially designated for a specific purpose that under the regulation, it's prohibited for any EU person to enter into any transaction with these companies. So that this restriction came in on the 16th of March. So as of that date, any new transactions became illegal, and then for, a grandfathering provision was entered for pre-existing transactions with those parties, and there's a window for coming into compliance. That window ends this weekend, in fact, on the 15th of May. So as at the 15th of May on Sunday, any historic or ongoing transactions with the likes of Rosneft or Gazprom Neft or any of the others on the list there will become illegal. So the need there is therefore for all persons in Cyprus to consider their portfolios and their trading relationships and to take appropriate measures. There's also, I should mention, there's an extension. It's not related entirely to this restrictions on transactions, but there was an extension to the capital markets restrictions that we saw in the previous slide there, a couple of slides back. Whereas in the past, the capital markets restrictions were limited to state-owned enterprises or banks, so VTB, Sberbank, Gazprom Bank. That was extended in 2022 to also include privately held banks, which up until that point had been seen as independent of the Putin regime. That changed, and so now really there's an outright ban on key credit institutions in Russia for the purposes of trade sanctions. So we've got some names here: Alfa Bank, Okriti Bank Russia, and Probsyaz Bank. I think there's a slight typo in there. And last point there, investment services in relation to any of the above. Again, any services that are ancillary to the main prohibition will always tend to be caught by the trade sanctions as well. bank account restrictions. So I'll hand back to Alina just to run through the restriction on accepting deposits.
Thanks, Aki. So further to the new types of restrictions being introduced under the latest measures in 2022, one of these has been to impose a prohibition on accepting deposits. So this would apply effectively to credit institutions, which come from Russian nationals, natural persons residing in Russia, or legal persons, entities, or bodies established in Russia in relation to deposits that exceed 100,000 euros. Now, an interesting thing to note here is that that is also the amount that is equivalent to the protection under the deposit guarantee scheme in Europe. So it's interesting that they've chosen that as a marker. An equivalent prohibition now applies in relation to the maintenance of crypto assets, crypto wallets, accounts, and custody services. Interestingly, this was introduced after the initial introduction of the prohibition on the deposits, and this was because there was an observed transfer of funds through crypto effectively environments, given the prohibition in Europe on actual bank accounts. Now, it's important here to say that the prohibition does not apply to nationals of a member state or to natural persons which have temporary or permanent residence in a member state. So if we have Russians who are allowed to reside in Cyprus, for example, or if you have a Russian who may also have a nationality of a member state, then that would prevail effectively. It is also important just to note for completeness, although this doesn't tend to be always relevant in the context of financial services, that this prohibition does not extend to deposits where this is necessary for non-prohibited cross-border goods and services between EU and Russia. That is, of course, a list that is quickly diminishing. And it is also possible to apply for an exemption from this prohibition to the competent authorities. So you need to obtain a license effectively to pay. So for the relevant person that is Russian and who wishes to deposit more than 100,000, to pay for basic needs, reasonable professional fees, and expenses related to legal services. These are the main ones. There are some others, but these are the key points that tend to be most relevant. So we had just discussed restrictions on bank account deposits. Now we will move on to another prohibition, which has been of a lot of relevance to Cypriot business. This relates to the prohibition on the sale of transferable securities. Now, just to be specific on what this applies to the sale of transferable securities which are denominated in an official currency of a member state. So for the purpose of Cyprus, that would include euro denominated, and which the relevant securities have been issued after the 12th of April of 2022. It also extends to any fund units, so collective investment scheme units, which provide exposure to such underlying transferable securities. And the prohibition relates to any Russian national, any residents of Russia, or legal persons established in Russia. So the sale to such persons is what is prohibited. Similarly, with the bank deposit prohibition, this does not apply to nationals of a member state or natural persons who have temporary or permanent residence in a member state. What is very important to note here is that there has been guidance that has been issued stating that, taking into account the provisions on circumvention, we will discuss that article later on, but taking into account those additional provisions in circumvention, guidance by the European Commission has stated that the prohibition has to be taken as extending to the sale of securities to a European entity, so Cypriot entities, who are in turn owned by one of the persons prohibited, so a Russian national, a resident of Russia, or a legal person established in Russia. Again, similarly with the deposit prohibition, it is for the same grounds you can apply for an exemption from the competent authority. So again, for basic needs, to pay reasonable professional fees, and for expenses related to legal services as the key points. Moving on, we thought it would be important to touch briefly on the SWIFT ban. So as I mentioned, earlier, a number of Russian banks have been cut off from the international SWIFT system, meaning that it is not quite possible to make bank transfers to them. We set out the relevant entities on the right there. So just to quickly run through them, that is Otkritie, Novicombank, Promsviesbank, Bank Rossiya, Sovcombank, Vneshekonombank, and VTB Bank. We also mentioned earlier that there is now a proposition to also cut off Sberbank from that list. I have a suspicion that there may be one missing, but we can check that for you. Now, moving on to perhaps what is of most interest in Cyprus to some extent. So referring now to the prohibition on trust services, which has been introduced, there has been a lot of discussion about what is covered under this prohibition on trust services. So just running through the issues, the one issue that is firstly prohibited is the registration, provision of registered office, business or administrative address, and management services to trusts or similar legal arrangements. So this refers effectively to new trusts. So from now on, what is additionally prohibited is the provision of the services of a trustee, nominee, shareholder, director, secretary, or legal or similar position for new trusts or similar legal arrangements. Now, when does this prohibition capture? This relates to trusts where the trustor, more commonly in Cyprus anyway, referred to as settlor, or the beneficiary of the relevant trust is a Russian national, a Russian resident, or a legal person established in Russia. So far we see that this is consistent with the previous bank deposit prohibition that we discussed. And however, this is slightly broader in that it also extends to legal persons which are owned by more than 50% by these persons, which are controlled by such persons, or which are acting at the direction of such persons. So we see that this is a fairly broad set of scope of application, and it needs to be assessed on a case-by-case basis. Now, what is also important to note is that there is a prohibition from the 10th of May to act as or arrange for another person to act as a trustee, nominee, shareholder, director, secretary, or similar position for a trust or similar legal arrangement to the persons we just talked about. So what this effectively has created, I guess, it's already, the moratorium is already up as of yesterday, but what effectively was created by this was that there was a moratorium to terminate existing trust arrangements by the 10th of May. So this was a subject of discussion in terms of the guidance that has been issued at the level of the competent authorities. Now, similarly, again, with all of the prohibitions we discussed, is that this prohibition does not apply where the relevant trustor or beneficiary is a national of an EU member state or has temporary or permanent residency in the EU. A couple of points just to make, which have come across our desk and we thought it would be useful to share today, is first of all that the term similar legal arrangements, we do not consider that this extends to companies. This has also been confirmed by guidance by the European Commission. So that is one very helpful point that has been made. And a second point to make here is that when we talk about trust, we consider that this will also capture bare trust. So nominee arrangements, as those two are a type of trust. So if we could move on to the next slide. So having run through the prohibitions, you're not allowed this, you're not allowed that, we thought it would also be important to just run through the protections that the legislation affords to people who do not fulfill their obligation because they're not permitted to do so. Because obviously, if you have undertaken to deliver a particular service and now you're not allowed to do it, that would create issues in terms of breach of contract and non-fulfillment. Now, speaking in the context of Regulation 833, we have protection from claims which will arise from a contract or a transaction, the performance of which has been affected by the relevant prohibition. So if there is a claim brought against you from effectively breach of contract or non-fulfillment, then there is a protection under Regulation 833 for not fulfilling the relevant action given that it was prohibited. There is also a protection provided for natural and legal persons where they did not know and had no reasonable cause to suspect that any actions taken would infringe the measures set out in Regulation 833. Now, here we think it is very important to point out that this is not a protection for a lack of due diligence as to who is behind a particular structure, and there's also not a protection for not being familiar with the prohibitions of the sanctions provisions. What we consider this to attach to is rather a situation where there was a genuine and justified lack of awareness of the person taking a particular action, which was prohibited under the sanctions. It is not intended to form as a cover for, you know, a lack of looking into or assessing who their counterparty is and who is behind that counterparty. And finally, moving on to a very important issue when interpreting the provisions of both the asset freeze and the trade restrictions that we're discussing here, is the fact that there are express provisions in the legislation which prohibit persons from participating knowingly and intentionally in activities the object or effect of which is to circumvent the EU trade restrictions. Now, what does this mean? This means that the relevant prohibitions must be read widely, and that where an action is undertaken purely with the view to find a way to do what is otherwise forbidden, then that too is intended to be captured. That is what this prohibition is trying to say. So 2 points are key here. The one is that if you are trying to implement measures with the purpose of, in a particular way, with the purpose of just avoiding what would otherwise be prohibited, then that too is prohibited. And then secondly, what is more important to what is often our role as advisors and service providers is the fact that if you are helping and advising a person on specifically how to structure an arrangement in order to avoid sanctions, then that too is considered circumvention, because what is that result is also ultimately prohibited. This is very important when interpreting a number of provisions under the rules, since that is tends to often lead you to take a more cautious interpretation of a particular prohibition. And as we mentioned, because the consequence here is criminal sanctions, potentially imprisonment, potentially loss of license, it is the intention of the legislator to make these prohibitions as tricky, effectively, and as wide as they can capture, to avoid people taking advantage of loopholes and to ensure that they're effectively implemented. Now, we have covered off the various EU trade restrictions. Now we will turn to certain considerations attaching to the asset freezes. And for this, I will hand over to Aki.
Thank you, Elena. I should just mention to Aki that we are running a little bit late, and that's the reason mainly why I'm not interrupting with questions. I'm jotting them down for later, but we have about another 5 to 10 minutes to complete the presentation, if that's manageable. Yes. Thanks.
Absolutely. So asset freezes. So as I mentioned earlier, asset freezes are the traditional form of sanctions. They essentially provide that any dealings or economic relations with a person that is expressly listed in a schedule to one of these sanctions will be an illegal act. So strictly speaking, what these provisions say in the EU is that there is a freeze on all funds and economic resources, and funds and economic resources each have their own definitions, which are extremely wide, belonging to, owned, held, or controlled by any natural or legal persons that is designated, or anyone associated with that person. So again, a very wide freeze. There's significant case law in various member state courts and also in the UK before pre-Brexit, as well as at the ECJ, as to determining who is considered to be in control. There's a lot of guidance out there as well that we can touch on. There's equally a prohibition on not only dealing but making funds available. So let's say there is a you have a bank account that is not in the name of a certain designated person, but those funds are made available to that person for use for whatever purpose, then that is a breach of the asset freeze restriction as well. So the idea is to cut off the economic viability of that individual or company from financial institutions and parties in the relevant jurisdiction. Next slide, please. Oh, there we go. Okay, so because it is such a wide-ranging and possibly very difficult sanction to deal with for persons that are affected, there is equally a broad range of exemptions that can apply. And so the idea is that if you are on one of these lists, then the likelihood is that you'll be applying to the competent authorities to seek a license. The licenses historically were granted for many purposes, but over the years, those justifications for issuing licenses have, through case law at the ECJ level in particular, been whittled down. And so we've got some of these down here. So, for example, the releasing frozen funds to pay for basic and reasonable professional fees, legal fees. So for example, if a law firm wants to defend someone that is on the freeze, then those any fee notes that are paid would need to be disclosed to the authorities, and as part of the licensing mechanic, only through the license would those fee notes be able to be paid. There are some others there as well, so enforcing arbitral decisions that are issued prior to the sanctions coming into force. There are some other grandfathering provisions there as well, and releasing frozen funds for the orderly wind down of operations. Relevant to banks alone, the crediting of frozen accounts for the purposes of interest payments and those sorts of things is permitted, provided that all of those funds are frozen and remain frozen at all times. The other one to mention is that the licenses for the maintenance of assets. So, for example, if there's a company and you have to pay the government a fee on an annual basis, that again is something generally that will be allowed. So the distinction between licensing is that it's there to maintain assets, not to allow those assets to become destroyed or to be confiscated by the state through lack of maintenance. So there are some defenses for non-performance. There are, similar to the restrictions under EU trade sanctions, there's protection for claims where there's a breach of contract that has been affected by the asset freeze. Obviously, if there's a contract that says X must perform a certain obligation for Y, and then Y becomes asset frozen, X cannot comply with that contract, and the statute, the legal regime expressly carve out liability in those situations. There's equally protection from liability for natural legal persons, including directors, for freezing or refusing to make funds available, unless it's shown that freeze was imposed as a result of negligence. So in other words, in short, what this is saying is the courts will generally back the credit and financial institutions where they err on the side of caution, freeze everything and are not willing, even if down the line there might be an argument that they went a little bit too far. The courts will generally side with the institutions in those cases. There is, as Alina mentioned earlier, there is protection where you did not know or had no reasonable cause to suspect that there would be an infringement of the regulation. But this is designed not to capture active participants in transactions, whether that be nominee shareholders or directors that sign off on things without realizing the full import of what they're doing. It's more to deal with the likes of banks that end up transferring wires across the world when there's no in large omnibus accounts, and they have no way of knowing that they're dealing with tainted funds. So it's not a protection, as Alina mentioned, to have little due diligence or a lack of due diligence on structures, or to not be aware of sanction provisions. Next slide, please. As mentioned before, I can skip through this quite quickly. There is an anti-circumvention prohibition in the asset freeze legislation. So it's prohibited to knowingly or intentionally engage in activities that seek, obviously, to avoid the sanctions. That's illegal. Next slide. Right, so here we get into the last part of the talk. We're going to go through some trade sanction practical examples. Over to you, Alina.
Before you continue, Alina, I should mention to our participants that they can start asking questions before the Q&A session through the chat, which we will be mentioning to the speakers to respond on. So if you have any interesting questions, please start putting them in the chat from now. Thank you. Alina?
Sorry. So just to save us time to respond to the Q&As, I will try and go through relatively quickly. So what we tried to do here was just to jot down some scenarios which tend to come up a lot and which tend to be of most interest to service providers and businesses based in Cyprus. So starting with the prohibition on trust services. So a scenario where we have a director of a company which acts as trustee for a Russian natural person resident in Russia, and assuming that none of the exemptions apply, so what we mentioned earlier about residency and potentially dual nationality and so on. So assuming just a Russian natural person resident in Russia, this would not be permitted. So acting as a director of a trustee based on that provision would not be allowed. Moving on to another question in relation to the trust prohibition. So acting as trustee of a trust for a Russian natural person resident in Russia, where such trust was established prior to the 9th of April. So this is a distinction we were making earlier about new and old. This being an old trust, it would again at this point be prohibited to undertake this activity, as we have now passed the date of moratorium. One last point, which we have actually already addressed in our previous slides. So the status of nominee arrangements. So as we mentioned earlier, nominee arrangements are a type of trust, bare trust, and on this basis, we would consider that it would be prohibited under the trust services prohibition. And another point, which again, we actually covered in the previous slides, is in the context of the prohibition on the sale of shares. So if you have a share purchase agreement to sell and transfer new shares which have been issued after the 12th of April to a Cypriot company, but where such Cypriot company is owned by a Russian natural person, again, based in Russia without any applicable exemptions, this would not be permitted. So these are effectively our examples in the context of the EU trade sanctions. Aki, I will turn to you in relation to some practical examples on the asset freeze.
Thank you very much. So this will be our last slide on the presentation. So asset freeze, practical examples. So we have the asset freeze essentially will prevent any dealings with a company that's expressly listed. So let's say we currently have, for example, VEB, Bank, expressly listed on the Russian asset freeze. But what about the subsidiary of that company? Is that frozen? So let's say VB has a Cypriot subsidiary. Is that subject to the asset freeze? And the answer to that is yes. There are very interesting questions surrounding the territorial scope of the asset freeze obligation, where you're dealing with an institution that's headquartered in Europe, let's say, but with subsidiaries in Russia or elsewhere, and what those subsidiaries can or cannot get up to. There's lots of discussion on that, but I'm afraid we don't have time for that right now. Happy to answer any questions. Then the next practical example. Oh, hang on, just finishing off on the last two there. So the member of the board of directors of an entity subject to the asset freeze. So the board of directors member, if they are, for example, an EU national based in Russia, or if they're based in the EU, generally speaking, will have some very difficult decisions to make with regards to their directorship. It would be very difficult to see how they could continue to act or do anything for that company if they're subject to the asset freeze jurisdiction. Similarly, for a secretary, there are some services that where the service provision is frozen, then nominally being on the register might be acceptable, but it really depends on a case-by-case basis. Right, Q&A.
Thank you, Aki. Thank you, Lina, for that excellent presentation. Again, to our audience, please start sending through the chat any questions that you may have. Let me kick off and ask Aki and Lina about the 2016 sanctions law, the Cypriot law. From its wording, it appears as if it's a strict liability offense that's there. In other words, once you do breach sanctions, immediately you are you're committing a criminal offense. But you mentioned there's some protection in the 833 regulation. Is it a defense under Cypriot law? Has that been transposed into the Cypriot statute? And to what extent? For instance, if I do breach sanctions unbeknownst to me, without any intention, is there a difference between a lawyer doing that and a member of the ordinary public, a layman?
So I think that the 2016 law in Cyprus doesn't expressly make reference to any defense on that basis, though the 2016 law does create a criminal offense, and within a criminal offense there is a mental capacity part of that, and there is the actual act of doing something. Though I think in reality the mental element would be, did you intend to do the act, as opposed to did you intend to breach sanctions? So therefore, if you intended to enter into the transaction with, frozen Russian bank, well, that's, I think, where the mental element would come in. There is, however, the 2016 law does act as a transposition legislation. So the way that we would interpret that is to say that if there is a defense available at EU law level within Regulation 833, then that should also be transposed through the 2016 law into the domestic regime. And so there, as we saw, there are some defenses where there is there's possibly no way that you could have known from the way that the system is built that you were breaching sanctions. So again, and the typical way of thinking of this is that you may have an omnibus account of some sort that's passing through banking institutions. There might be some tainted funds in that account. The bank could rely on that defense. So it's not a strict liability offense from that point of view. There is a, and it's also if it's reasonable in the circumstances as well, taking everything together. And I think for that, what the authorities often look at is what would they generally expect an equivalent firm or institution to have in place. And if it's through a lack of systems and controls or compliance mechanics, then that will be problematic, and that would potentially contribute towards full liability there.
Thank you, Aki, for that. And presumably, even if the 2016 sanctions law doesn't completely transpose the defense that the EU regulation provides for, the regulation will still have direct effect and will supersede the Cypriot law in that case, right?
That's right. I mean, the way I think we would always try to interpret the 2016 law in a way that is compatible with the regulation.
There are a couple of very interesting questions coming through. One is from Elina Yalou. She asks, can an insurance company proceed with covering a Russian national if the valuation of the insurance scheme is over and above 100,000 euro? And I can add to that question, does the answer change if the Russian national has a Cypriot passport or is a permanent resident in Cyprus?
So there are some restrictions on insurance policies outright, on reinsurance, especially in the context of aircraft. At the moment, though, there isn't an outright ban on the provision of insurance to Russian nationals in the same way that there is in the trust services
and
scenario.
bank deposits. So
And bank deposits.
to the extent that the 100,000 was in the context of the banking deposit, just to point out that that is in the context of deposits and hasn't been extended necessarily in the context of insurance. And just to respond perhaps to George's additional point, we consider that each case has to be assessed on its facts, just to make sure that the relevant prohibitions and exemptions are accurately taken into account. But in principle, yes, as we mentioned earlier, there is an exemption relating to temporary or permanent residency and for effectively dual nationality.
Okay. Elena, you mentioned before, talking about the trust restrictions, that companies are not included. However, nominee arrangements are included. Wouldn't that catch companies and the nominee shareholder of companies?
Well, what would be captured would be the trust arrangement rather than a prohibition on, for example, being a shareholder of the company. That is rather what we wanted to point out. There was some concern.
The trust, when we're talking about trust arrangement, we mean the declaration of trust, which is typically put in place between the Russian national and the Cypriot nominee shareholder of a company?
Yes. So, for example, if I sign a declaration of trust saying that I hold these shares on trust for a particular person who happens to be prohibited under the trust prohibition, then that is a bare trust, as we refer to it, or nominee arrangements, as we often refer to it in Cyprus. And that is a type of trust, and therefore would be caught within scope of the prohibition. That is the point there. Yes.
Thank you, Lina. Another interesting question from Stavros. We are a Cypriot and Cypriot-owned company with 100% Russian subsidiary, and they need to send funds, which is less than 100,000 euros, to their subsidiary to cover their ordinary business, their day-to-day operating expenses. Can they do this? And the subsidiary is banking with an Austrian, the branch of an Austrian bank in Russia.
So in principle, yes, they can do that. So as long as they're not dealing, it doesn't sound like they are with any of the frozen banks in Russia. At the moment, there isn't an outright ban on sending transfers across from the EU to Russia. We saw in the context of Iran, before there was the JCPOA was put in place, there was an outright transfer ban on any funds going across between Iran and the EU, and we haven't got there yet for Russia, and that's why there's been so much emphasis as well, I think, on all the SWIFT exclusions, because in that situation, what they're saying is that certain banks that are closely affiliated with the Kremlin are effectively blacked out of the global money transfer system, but others are not. Having said all of that, it may in practice be very difficult to transfer funds from Cyprus to Russia. We have seen extreme caution on the part of Cypriot banks. We understand that there are various supervisory warnings from the CBC, Central Bank of Cyprus, in this area. So although the answer as a matter of pure sanctions law would be that in theory, yes, that should work, there might be practical obstacles to doing so.
A tangential point that just comes to mind, actually, from what you've said, but isn't really related to the question, is just to say that We have become aware of a number of complaints, for example, where accounts may have been frozen, and the owner of the account considers that that wasn't correct, or it wasn't reflective of the status of the company. And in response to these types of controls, we are aware that SEOC, so what we mentioned earlier, the competent authority responsible for processing issues around banking and so on, has expanded recently its competency to take a position and a view in response to complaints for unfair or incorrect freezing. So I thought that might be relevant to the group here as well. Again, that would effectively be in the form of an application process to the competent authority.
Thank you both. There seems to be a lot of interest from insurance companies and people asking insurance sector related questions. What happens if there's a claim payable to a Russian national, presumably from a Cypriot insurance company?
So I think that the question would be whether the policy itself is prohibited. So as I said, some insurance policies will be, and so we need to understand whether, you know, what is the exact item being insured. But in principle, if that's not subject to the restriction, then a payout may be possible, but again, we would just need to, I think, understand the facts in a little bit more detail before saying that's fine, because again, a payout would require transfers to Russia to be made, and there could be various issues there.
Thank you, Aki. I have a question on contractual performance. You mentioned that 833, the regulation, prevents the performance of contracts if they breach the sanctions. So if you're a contracting party in Cyprus, can you base a claim or an argument of force majeure or impossibility to perform or frustration of the contract based on the regulations provisions?
So there is a general protection from any liability. So the reality, I think, would be that you wouldn't have to resort to the question of frustration or force majeure. So even if you have a contract that doesn't include a force majeure clause, and we know that frustration is a difficult concept in contract law to deal with, and it's very picky as to what's included. You know, the statute is quite clear that there will be no liability as far as the local law goes. So any EU member state goes, there will be no liability for a failure to perform if that failure is caused through a desire to be sanctions compliant.
Thank you. Another very interesting question. If I have trading activity with a Russian firm or a sanctioned party, what steps should I be taking to ensure that I comply with the regulations, with the sanctions, essentially?
So I think here I would firstly make the distinction between the trade restrictions and the asset freeze restrictions. So if we have an asset freeze, as Aki outlined earlier, there is effectively an outright a complete ban on dealings with such a person. So that is any transfer of assets to or from the relevant asset frozen party is effectively prohibited. So that is one thing. Now, in the context of the trade restrictions, what is and is not permitted closely depends on what the subject matter of the particular transaction is. So it's very difficult to say what needs to be done without further clarity and further information on what the precise trading is. Appreciate that's not very helpful, but I think the main distinction to make is, you know, first of all, is this person asset frozen? Yes, no. And then if not, then you would need to make further inquiries to establish whether the specific thing that you're trying to do and you want to do, whether there's any prohibitions attaching to that.
Thank you, Lina. An interesting question on the prohibition on the sale of transferable securities has been sent. Does it also cover the allotment of shares? And if I cannot, if I may add myself, would that also include GDRs, for instance, which are not in the name of the Russian national, but are held by a custodian?
Let me just answer the second part first. So in relation to GDRs, GDRs would be a type of transferable security, so they would fall within scope in principle of that definition. Now, in relation to the allotment of shares, Aki, do you want to run through our very long discussion, or shall I?
So I think, I think the view that we, I think we do await further clarification from the EU on issuances, but in the absence of that guidance, there may be good grounds to suggest that an issuance is not intended to fall within the relevant prohibition on the sale of securities, but it will, because an issuance is precisely that, it's an issue, and so in that situation you don't buy and sell, you issue and subscribe, and we have seen elsewhere in other provisions of Regulation 833 wider use of those terms. There has also been some local guidance suggesting that issuance is not intended to be caught by the provision. So I think what I would say is it's one to tread carefully on. I don't think that it would be wise to say that all issuances will be permitted, and it does depend on a case-by-case basis. But having said that, there may be good reasons to say that many issuances will fall outside of scope.
Thank you, Aki. The sixth package, which has not yet been adopted, as you mentioned, will apply in relation to the provision of services by accountants, consultants, and spin doctors. Can today lawyers, accountants, and administrative service providers still continue to act for Russian clients? And to what degree can they do that?
Elena, do you want to answer that one?
Yes. So again, it depends in each case in the context, or the specific context of the service. So starting first of all with the sixth package, as we said, at present that hasn't gone through. Then going back to the distinction that I made earlier between asset freeze and trade restrictions. So if a person is on the asset freeze list, then it is prohibited to provide sorry, let me roll back for a second. So the asset freeze relates to providing economic benefits effectively to the asset frozen person. That is one of the prohibitions. Now, there is a long discussion and analysis as to whether the provision of services to the person as such is part of the asset freeze. So first of all, in certain cases where you may provide the services, you may not be able to get paid by that person. And generally, our recommendation is where you are dealing with an asset frozen person, even if the advice that you obtain says is that you can continue to provide the service, always without payment, because this isn't prohibited. It is best to apply for an exemption, a license from the competent authority to, first of all, sort of bless your continued acting for the particular person. And secondly, of course, to authorize the payment of your fees in accordance with the exemptions that we discussed earlier on. So I think that is the main point in the context of an asset freeze. Now, in the context of the trade restrictions,
just before we move on to the trade,
yes.
I'll just add a footnote onto that bit about the asset freeze. There, I would say that we do have this chicken and egg situation sometimes with the provision of services for no fee to an asset frozen person, and if we are being asked, for example, to apply for a license for an asset frozen person, then in a sense, if we take the view that the provision of a service for no fee would similarly breach the restriction, then we face this catch-22. We're not able to apply for the license because the service itself is treated as frozen, and so that person can never obtain a license. So there is some leeway within the system for those sorts of services. But again, it can't be if the service is provided for no fee because they really wanted to provide the service for a fee, but they can't because of the sanctions. Then we have anti-circumvention issues coming into force there. And so it's the idea is what's the object or intent of the arrangement?
Yes.
Thank you very much. A very interesting question from Michael, and this has to do with the impact of the sanctions on the trust arrangements again. There was some confusion when the fifth package was adopted as to nominee arrangements and trust deeds. The Cyprus Bar Association came out saying initially that the restrictions do not apply to nominee arrangements and trust deeds, whereas the Ministry of Finance, I believe, said something else in its announcement. What does apply? Can you please repeat exactly what is covered and clarify that for us?
Shall I run through the order perhaps first of the announcements?
Yeah, that would be great. Yeah. Would you like me to run back to the slide? Would that be helpful for you?
That's fine. So there was an announcement effectively issued by the Cyprus Bar Association, taking a view that old slides old trusts were caught within scope. Then there was a almost parallel announcement issued by the Ministry of Finance, taking a view that old trusts were not caught. However, following the conflicting advice, obviously, the Ministry of Finance issued a further announcement stating that they are seeking clarifications from the European Commission on the point in light of the diverging position issued by the Cyprus Bar Association, and that they would revert with a further update once they had heard back. As such, it is left to basically the individual consumers of that prohibition to take a legal advice, we would say, as to what the actual scope of that provision is. Now, once again, it is very important in the context of sanctions to take advice on a case-by-case basis. However, what we have observed during our review of this provision is that there was a moratorium imposed in terms of old trusts. So, to the extent that there is a deadline imposed with a specific reference to trust established prior to the 9th of March, I believe, or 8th of March, on that basis, our view was that it was caught. Now, in the context of nominee arrangements, I don't recall exactly right now what exact guidance has been issued. However, as I mentioned earlier, a bare trust is a type of trust, and in the absence of something to the contrary, we would generally take the view that there hasn't been an exemption for nominee arrangements unless it's somehow expressly stated. I would also mention that in the provision, which is Article 5M of Regulation 833, there is in fact a specific and express reference to the term nominee shareholder. So that too is something that has to be taken into account when making the relevant interpretation of the law.
Thank you, Lina. Sorry,
the other point I would just mention that it's quite interesting when you look at all the guidance that the European Commission has released on all the various parts of the trade sanctions measures. This restriction on trustees is not included in that package. So no express guidance has been yet released on this. And I think so some of the as Alina was making reference to earlier, some of the issues surrounding the issue about nominee holdings and bare trusteeships being in or out of scope is because there was a 2019 paper that did talk about types of trusts. We generally perceive that paper as descriptive of the trust regime as opposed to prescriptive of what is a trust for the purposes of Cypriot law. And other common law member states, well, the only other common law member state now is Ireland, did expressly refer to a wider type category of trusts there, which would be equally relevant in Cyprus. So yes, we generally take the view that bare trusts and nominee shareholdings and that sort of thing are included. And that seems to be the approach taken by the market as well, globally.
Thank you, Aki. Thank you, Alina. What is the practical risk of breach of sanctions, says our latest question. Alina, you mentioned something about imprisonment at the beginning under the 2016 sanctions law. Has anyone gone to jail, as far as we know, up to this point? Has anyone been prosecuted? What will practically happen if I breach the sanctions?
So just to start that, to my knowledge, I am not aware of someone having been imprisoned for breach of sanctions in Cyprus anyway. Now, in terms of the practical considerations, I mean, the first point is that, first of all, there has to be established that there has been a breach, and relevant reporting and action has to be taken by the relevant competent authorities in accordance with the legislation. I think what will be possibly a more immediate consequence of having been found to be in breach of sanctions is probably, if you're a regulated institution, you would probably see immediate enforcement action being taken by the regulators, for example.
Suspension of your license, for instance? Potentially,
for example, even termination of your license, depending on what the situation is. Now, of course, in every, like we said, it's a criminal offense. So that would have to go through the proper process. The proper evidence would need to be furnished and so on. So it remains to be seen what that process actually looks like in the event of enforcement. However, it would follow normal criminal procedure in that respect.
So the police would be called in to investigate, presumably, and then they would prepare the file and send it to the Attorney General to decide whether to prosecute or not.
The truth is, I am not a criminal lawyer, but
that's a process.
That's correct, George. A breach of sanctions. I mean, we've worked on cases where there has. I mean, typically what happens is, especially if there's a financial services aspect to it, is that the regulators in Cyprus get very engaged. You may well have the police engaged, MOCAS as well can get involved, and that the file is built as any criminal case would be, and in this situation sent to the Attorney General for a decision on whether to prosecute or not. What we've generally seen is that I think the fact that there haven't been many cases that we're aware of anyway in Cyprus is more a reflection of the fact that up until now, a lot of the actual acts that have breached sanctions have tended to occur elsewhere outside of Cyprus, and certainly in the cases that I've worked on, the money flows have tended to be elsewhere. Somehow, whether that be in other member states or outside of the EU. I think the trade sanctions, in particular the restriction on trusts, changes that, and there's more scope now for local prosecutions than there wouldn't have been. And in particular, if there's if there is a sixth package, if and when the sixth package gets introduced and there's a restriction on accounting services in the EU, then that will very much put the cat amongst the pigeons as far as Cyprus is concerned.
Yeah.
So, yeah.
Thanks, Aki. I think we have run out of questions. The presentation was so informative and to the point that I think you have covered most of the questions that the audience wanted to ask. Unless you have something to add, I'll wrap up and thank everyone for attending.
There is
Yes,
one
please.
thing that I would like to say before we close off. Sorry for interrupting you there.
No, please.
It's just that we provide regular updates on the developments that are happening with the sanctions on our Harneys regulatory blog. You're also able to sign up to our updates from the blog or other legal updates through our website. I'm just sending the link now on the chat. So, you know, if there's anything that you need, please feel free to refer to those materials. And of course, you can always reach out to us as well directly.
Thank you, Lina. And we should mention that the video will be posted on OEV's website and on Harneys' website. And the slides will be sent around to the participants. If they have any questions, they can reach out to OEV or to us directly. We'll be happy to respond with an answer to any legal questions that they have. Let me take this opportunity to thank Antonis Frangoudis for being with us and Michael Grigoriou for all the help with organizing this. And of course, a big thanks to the Director General of OEV, Mr. Michael Antoniou, who immediately accepted our invitation to co-host this webinar. And hopefully it was helpful to the participants, and they will take some information away and use it in their daily professional lives. Donis?
Yes, I would also like to thank Harneys and George, Aki, and Elena for their presence and valued consultation today. And of course, all our guests. I hope that we have all gained the knowledge to see what's happening and be able to face any future crisis like this. Thank you very much all, and I would be happy to see you in any future similar events.
Thank you, everyone.
Excuse me, can you hear me?
Yes, we can.
Yeah, George, I just posted a question in chat. I'm not sure if you addressed it earlier.
No, I must have missed your latest one. Please go ahead.
So
we're about to sign off, but please go ahead.
Yes.
Sorry about that. Regarding the prohibition on trusts on the 5th package, there is paragraph 3 of Article 5M that says that paragraphs 1 and 2 shall not apply to the operations that are strictly necessary for the termination by 10th of May of contracts which are not compliant with this article concluded before 9th of April. What do they mean exactly by this 9th of April date?
So at a high level, the way we read this prohibition is the moratorium that I mentioned earlier, with basically imposing a deadline to terminate existing arrangements of trusts, which are not allowed under 5M.
Okay, the deadline is 10th of May to terminate those trusts.
Mm-hmm.
But what about them? It says concluded before 9th of April.
Yes, so these measures, so 5M was introduced and came into force basically on 8th of April, so starting from 9th of April. So what it's trying to say is that under Article 5M1, as far as I remember, it basically says no new trusts from today, being 9th of April. And then it tells you, and you have until 10th of May to terminate existing trusts before 9th of April, because that was the day on which the measure was first introduced, and you have to do it by the 10th of May. So it's a moratorium.
That's fine. Thank you very much.
You're very welcome. Thank you, Aki and Elena again. And we'll meet again with everyone in the next Sanctions seminar, hopefully soon.
Thank you
Have a
very
nice
much.
day, everyone. Bye-bye.
Thanks, everyone.
Take care. Bye-bye.
Bye.
Bye-bye.
Bye, thank you.